Have you ever seen that familiar little letter C in a circle, followed by a year and a name, at the bottom of a book, a website, or a piece of art? It is the universal symbol for copyright, and it often leads people to wonder, is this little mark truly necessary for protection? Well, to answer directly, yes, United States copyright law absolutely once demanded a notice to secure and maintain protection for creative works. This requirement was a fundamental aspect of copyright law for a very long time, but it changed significantly in recent decades. Historically, the United States copyright system was built on a series of formalities. Under the Copyright Act of 1909, if you published a work without including a proper copyright notice, you risked losing copyright protection entirely, potentially dedicating your work to the public domain. This was a very strict requirement. The idea behind it was to clearly inform the public that a work was protected, to identify the copyright owner, and to state the year of first publication. This helped others know who to contact for permission and when the copyright might expire. The landscape began to shift with the Copyright Act of 1976, which softened the requirement somewhat. While notice was still generally required, omissions could sometimes be cured, meaning you might have a chance to fix the mistake and retain your copyright. However, the most significant change arrived with the Berne Convention Implementation Act of 1988, which became effective on January 1, 1989. This act brought the United States into alignment with the Berne Convention for the Protection of Literary and Artistic Works, an international treaty that champions automatic copyright protection from the moment a work is created, without the need for formalities like notice. For works published on or after January 1, 1989, the copyright notice became entirely optional under United States law. So, what does this mean for creators today? Even though a copyright notice is no longer legally required for your work to be protected, including one still offers several practical benefits. It serves as a clear warning to potential infringers that your work is copyrighted, which can help deter unauthorized use. It also helps defeat a claim of innocent infringement in court, because the infringer cannot reasonably claim they did not know the work was protected. Many creators still choose to include the notice to clearly communicate their ownership. The specific format of the copyright notice has always been a key detail. It traditionally consists of three elements: the copyright symbol, which is the letter C in a circle, or the word copyright, followed by the year of first publication, and then the name of the copyright owner. For example, it would appear as copyright 2020 for your name. The shift away from mandatory notice with the Berne Convention was a big deal because it meant American creators automatically received protection abroad and foreign creators automatically received protection here, streamlining international copyright. Before this, United States works often needed to jump through extra hoops to be protected in countries adhering to the Berne Convention, and vice versa. Ultimately, while the days of mandatory copyright notice are behind us for most newly created works, understanding this historical requirement highlights the evolution of intellectual property law. Today, your creative work is automatically protected the moment it is fixed in a tangible form, whether you put a notice on it or not. However, strategically placing that little copyright symbol still acts as a powerful public declaration of your rights, reinforcing your ownership and offering practical advantages in protecting your valuable creations.